Jessyca, how are you?
Good. Thank you, Maya. Thank you for having me.
I'm very happy to have you for the first time as my guest ever interviewing you, and hopefully it will be the first of many times to come in the future. Jessyca, I've known you for many years, and I'm sure a lot of people who are watching this interview also know you, especially if they're from the criminal law world. But I'm going to let you introduce yourself for anyone who's new to you or to the channel and who doesn't really know much about you. We'll start with an introduction about who you are, and then we'll get to talk about your niche area of practice.
That sounds great. Well, thank you so much for having me on. I appreciate it, and you are an inspiration to all of
Oh,
us doing this great work and awesome podcast and showcasing, the important leaders we have in the profession. So, a little bit about me. I'm joining you from Toronto today. I grew up in small town Ontario. I went to law school at Windsor. I'm in my 17th year. I'll be going into my 18th year in June. I know I look too young for that. I'm just kidding. But I've been started out in practice doing criminal law exclusively. And then during the pandemic, I branched out and learned the area of employment law. And what I found was that there are not a lot of lawyers who have this cross training doing the defense work in criminal law has a lot of application in employment law for people who get in trouble at work. So I represent a lot of individuals and sometimes businesses where there's going to be police involvement or there's criminal overlap.
well, this is a very important area or niche that you have developed, just like immigration is also very important for criminal law. Employment is also one of these important questions that many of our clients are concerned about because invariably any criminal charge is going to have an impact in one way or another on their employment. And this is exactly what we're going to be talking about right now. So, one of the things that let's start with Jessyca, what happens when a person is facing outstanding criminal charges? How does that impact them? Should they, first of all, let their employers know, or should they not say anything until they have a disposition? What should they do other than panic? Because that's the number one thing that happens.
I do get a lot of panicked calls. That's
Yeah.
true. And it's really hard to see clients in this situation
Mhm.
because your job and your employment is critical. It's essential to how you support your family. You probably worked really hard to get that job. Maybe you went to school for many years. So thinking about the prospect of losing your job just because you're charged criminally can be very devastating and overwhelming for clients. So, looking at that, it depends on a few things. If the individual is part of a regulated profession
Yeah.
where they have to report being charged, we don't have a lot of discretion. There isn't a lot of room to work with. In other cases, clients are bound by what's contained in their employment agreement or the workplace policies. So if you work for a bank, for example, some kind of auditing firm, private investigation firm, or other, insert name of industry that has a high degree of trust and authority placed in their employees, you may be required to disclose even if you're charged. And the timing about when can also be a question that requires advice. Some policies and employment agreements say you have to disclose right away.
Hmm.
Doesn't leave a lot of room for discretion. Other times, we may have some wiggle room if we know, for example, the charges are going to be withdrawn at the first appearance or the Crown's going to offer some form of resolution. There may be a bit of time and that we can delay and then offer the employer these charges happened, but this is how it's going to be resolved. And so what I do a lot of is I work with the criminal lawyers, I work with our colleagues to provide that employment law advice so that the client can really be covered and really have a solid plan to move forward on what their obligations are, what the risk is if they don't report it, and the best strategy so that they can move forward.
And if they are required to report right away, does that automatically mean that they will be terminated from their employment?
It depends. Typically, the employer will have questions, and the employers going to assess whether that person is a risk in the workplace, whether it poses any kind of a safety concern for the workplace, or there's reputational issues that the employer needs to consider. In some cases, what an employer may do is place the person on an administrative leave or a suspension.
Hmm.
That might be with pay or without pay. For example, publicly traded companies, if their CEO is charged, they're required to disclose that to the TSX, and the TSX will conduct their own investigation. The person can be brought back to work or not. So it really depends on the industry. In some cases, if the reputational issues are too high, the company may decide to end the working relationship with that employee, either for cause or without cause. And the individual may need advice about that. So lots of moving parts there. But what I will say is it doesn't necessarily mean that you are going to be terminated because, of course, we have the presumption of innocence.
Yeah.
And if you have a defense and you haven't been found guilty, you may be able to work with your employer to delay that decision until the criminal matter's been dealt with.
Now, does the nature of the criminal offense have an impact here? Like whether the person is facing, let's say, a sexual assault versus an impaired driving. Many of the cases are usually impaired driving. Obviously, we know that they don't really mean the same thing. Like one of them is more like a violence offense. The other one is more, you're coming back from a Christmas party and unfortunately you didn't, you made a bad decision here.
Right.
So is that also something that is taken into account?
I would say the offense does matter
Hmm.
because, for example, if you are a first responder, like a firefighter or a police officer, and you're alleged to have committed some form of child abuse
Yeah.
or other kinds of abuse with a member of the public, that is going to be deeply concerning for your
Yeah.
employer, and it's going to mean that you can no longer do your job, which may in and of itself break the employment relationship. It means
Hmm.
that you can't do that line of work anymore because you're not
Even if
qualified.
even if it's just an allegation yet, like he hasn't had a trial, like
Well,
that.
in some cases, the position the employer takes is you're no longer eligible to pass a vulnerable sector check,
Hmm.
and they won't take the risk by having you out on the road or dealing with the public. However, if you have an impaired driving or something far more discreet that maybe is related to substance abuse issues or
Yeah.
mental health issues, it's a lot easier for an advocate to negotiate a resolution to that where you could get treatment or therapy or go to counseling or substance abuse rehabilitation programming and then go back to work and you're not a risk to the safety of the public. It really depends on the position and the type of offense. And of course, we all know as criminal defense lawyers that we're living in a world where sexual assault in the public sphere is part of the bigger dialogue
Yeah.
that's going on in society right now. And I think even if you have a great defense, it makes it very difficult for you to continue in your position because employers just don't want the reputational risk.
And from your experience, Jessica, do you find that sometimes employers are open to a discussion with their employee? Like, is there room for the employee to explain a little bit the context of the offenses? Like, let's say, for example, it's someone who's in a domestic violence case, and it's something that happened while he was having a bad day at home, and then the wife, sometimes these cases happen where the wife is just mad at him, and so she just calls the police. Is there room for that discussion to happen with employers, or no? It's like right away.
I would say that there is definitely room for employees to have discussions with their employer, and
Mhm.
that's always going to depend on the size of the employer, the nature of the relationship between the
Yeah.
employee and the decision makers. But that said, as a defense lawyer and the considerations we have to take into account when we're representing someone who may have a criminal trial is you don't want your client giving a statement to their employer that could somehow make its way into the hands of the police or investigators and be used against them at a trial. You don't want any statements to be made So there
Could
is
the
a
lawyer,
delicate.
though, could the defense lawyer just give a brief explanation of the
Oh,
nature,
sure. That's a
you
great
know?
idea.
Yeah,
And in
like,
fact, that is a big part of what I end up doing is strategizing with the client about the best way to present themselves.
yeah,
And if it's a very sensitive case and we don't want the client to give any statements
of
to
course,
their
yeah.
employer, of course, the lawyer can intervene and try to have those discussions on the client's behalf. Or I would write a letter that outlines the allegations and what we anticipate the client's position would be at trial, so that can't be used against them.
Yeah, and at least, just make it clear that the client is denying, let's say, the allegations and they're going to have a trial and, just to kind of minimize a little bit the damage for the clients. Because the other issue here, Jessyca, is that sometimes if a decision is going to be made on the employment level, let's say maybe at least pending the disposition of the criminal charge. Sometimes it takes time, depending also on, the type of case. If it's a case that's going to superior courts, judge and jury, it may take several like months, sometimes a year, that the client will be on hold and they want to be able to continue with work. So tell us a little bit about that discussion because it's a very stressful time for the clients when they feel like they're going to have to lose their jobs and they don't know for how long. It may be longer than what they're anticipating.
Absolutely. Well, these discussions are heartbreaking,
Yeah.
especially in situations where the client is going to be on some type of leave without any pay. That just presents so many challenges, right? It's how do I pay for my defense lawyer?
Yeah.
How do I support my family? And it's, of course, doubly heartbreaking where the person tells you that these allegations are false. It's my practice to do everything I can to try to get them back to work or some form of work so that they can maintain their self-confidence, their mental health, have the financial means to support themselves. There's lots of different ways that we try to deal with that. Maybe it's negotiating some kind of a paid leave. Maybe it's negotiating other conditions that they work from home and do their job from home and
Hmm.
they're not
Yeah.
interacting with colleagues or the public. But it really depends on the type of position, right? Some of the first responders I work with don't have that option. They're on an administrative leave and it's unpaid, and the only recourse they have is applying for unemployment insurance, which isn't, that much.
So that's a very difficult situation. And then in that case, it will be really important for them to kind of get to an end with the criminal case as soon as possible, especially if their goal is to get back to their job, which in many cases, if they're licensed, like this is the only thing they're qualified to do. So it's really important for them to get back to their job as soon as possible. So which leads me actually to the next theme that I wanted to get into with you. Then how would you advise the client to decide on what to do? Because sometimes really the client is more focused on their employment and their decision about how they want to proceed in the criminal cases. Well, what can I do to minimize the impact on my job? So the decision as to whether they should take it to trial or get a plea deal and what type of plea deals are good for the clients in these types of situations.
Well, obviously, the best outcome is a withdrawal of the
Yeah,
charges.
yeah.
That's so anything that we can do to get to that point is the ultimate goal if that can be the case.
Hmm.
Obviously, there's some facts and cases that are just so serious that a
Yeah.
withdrawal is not going to be on the
And in
table.
sex
Uh,
assault cases, it's unlikely that it's going to happen.
Right. But in some more minor
Yes.
cases, you have a young person having the defense lawyer with an employment impact letter in hand. Let's say the young person is in their early 20s, they're in medical school, and they, broke something and got charged with a mischief. Well, there's a good chance that we may be able to get that charge withdrawn.
Yeah.
They have a great defense lawyer. I'm on board working with the criminal lawyer and we can provide some kind of documentation, which is an employment opinion on what a criminal conviction or even a peace bond might
Hmm.
have on their
Yeah.
process. That's like a best case scenario. That's sort of an easy case. Having an employment impact type of letter can be really helpful as a tool for defense lawyers to use in their negotiations with the Crown. My firm does a lot of those, and we, assess and provide an opinion on the difference between a withdrawal versus a peace bond or a conditional discharge, whatever the defense lawyer asks us to assess. And that's customized to the client based on their industry and what their nature of their employment is. But sometimes you have cases where really what we're doing is damage control, right? Like how do we get the client out of this without getting themselves into an investigation with their employer and not finding themselves in more trouble? And in those sort of damage control type situations, we may be talking about a resignation that avoids the person being terminated for cause, which is the capital punishment of employment law, as you'll hear my employment colleagues say. No one wants to be terminated for cause. That's like an employment record that's going to
Yeah.
follow you. And while it's not documented anywhere, a prospective employer may ask you that on a future job application. Have you ever been terminated? If so, was it for cause? And those are questions that generally can be asked, and you're not being discriminated against by being asked that question. And as we all know, if you answer in the affirmative, that might be
Hmm.
the end of your being considered for that position. So really, it does depend on the facts and the scenario that the person is in, and we analyze all of that to try to help them put themselves in the best position to move forward with something else.
Now, you did mention peace bonds, and in many cases, a peace bond is a very good way to resolve a criminal case. But for some types of employments, even a peace bond can be problematic. So, can we talk about in more specifics about peace bonds? When can they be a problem uh, in terms of employment and the difference between a peace bond and withdrawal for employment purposes?
Absolutely. If the person's in a regulated profession, let's say they're a healthcare provider
Hmm.
or they're a first responder and they're required to have a vulnerable sector check, they wouldn't pass a vulnerable sector check during the time that they're on a peace bond. It would show up as a judicial matter on either the vulnerable sector check or the judicial matters check. So that can have an impact on a person's employment. And in some fields, you have to have that check done every year. For example, teachers have to sign an attestation and have a background check every year, usually
Hmm.
in September. Some law enforcement agencies are the same. Other medical professionals may have to undergo similar types of checks. So a peace bond can present a problem. And then you get into a situation where
While it is active, right?
well, it
Or
is active.
okay, but if it's past the like when once the peace bond expired, does it still continue to be problematic?
You can write to have your fingerprints and photographs destroyed, and I hope
Okay.
all of our criminal colleagues are doing that. And then it should not be disclosed. No, after a peace bond has concluded,
Hmm.
it shouldn't be disclosed unless there's some exceptional reason.
Okay. Okay.
And there is a helpful chart that we can take a look
Yeah.
at. And when I'm answering these questions, I tend to refer to this chart, I would say almost daily. So I'll just bring it up here.
Yes.
This is the Ontario government's resource on police record checks, but you can actually just go to the legislation and take a look at the Police Record Check Reform Act from 2015, which at the end of the legislation has a great chart that you can take a look at. There's a snippet of the chart at the bottom here of this resource, which is on ontario.ca's pages under police record checks. And so this tells you if you have a criminal conviction, will it be disclosed on a regular criminal record check, a judicial matters check, or a vulnerable sector check? So let's just go down to peace bonds.
Hmm.
Um, so a peace bond counts as a court order. It's not going to show up. Uh, it's not going to show up on a criminal record check. So if you just pay the $35 and go on Triton and see whether or not you have a criminal record, if you had a completed peace bond, that should not show up. But a peace bond may be disclosed if it's still active, even if the charge was withdrawn, which you'll see there. And if you are subject to a restraining order under the Family Law Act or any of these acts, it may show up. And on a vulnerable sector check, a peace bond would also be disclosed. Now, this is again while they're active, even if the charge was withdrawn. But otherwise, once the peace bond is concluded, it should not be disclosed.
Right. So
Uh,
so one thing here for the peace bond is if you're able to get it for less than a year, like 4, 6 months, to minimize the time that it is active so that the person can right away be able to go back to work.
Absolutely. That's a great point to have the conditions be as short as possible.
Mhm.
In some cases, what I would recommend is you pitch that the person serve their peace bond up front. They stay charges pending for a bit longer and demonstrate a period of stability where they're following the conditions and there are no issues, and try to get the Crown to agree to just withdraw it then after 4 months, 6 months, whatever the timeline is. And in some cases, when you have this type of employment impact and it's really going to negatively affect the person, the Crown's more willing to negotiate a resolution like that.
And the letters that you write, Jessyca, that you provide, and this is obviously for anyone who's watching this, like Jessyca's firm, like you mentioned, this is what you do. So I encourage everyone to get in touch with Jessyca and her firm if you need help with those types of letters. Usually, so you can do that even if you're not the criminal lawyer on the case, right? Like if, let's say, I have a client and I need an employment letter, you can still do that, right?
Definitely. It's a big part of what I do is working with our colleagues. I'm not interested in mowing anyone else's
Yeah.
grass. I don't want to take their clients away.
Yeah.
I love working with other lawyers and assisting them with the strategy of the case, especially where there's some aspect like this, the employment, like you've said, which is so important to the client and can have a devastating impact on the rest of their life. The clients are usually very happy to have someone come in who's understands the employment ramifications and can speak to that. And that way the criminal lawyer is staying in their lane and I'm staying in mine. It's not my job to negotiate the peace bond. It's my job to give them an opinion about the impact of that.
Now, one thing that I do want to ask you about is that sometimes with crowns, we see, and it depends on the crown. I don't want to say that it's a general thing, but sometimes there are some crowns who are more difficult, where despite the letter, that clearly shows that even a peace bond will be problematic. And that is also with people who work for the government. It's important, not even a peace bond can be problematic. The crowns will still be, I don't care. Like they'll have to, like it's a peace bond. We're not going to, withdraw the charges without the peace bond. What what strategy does the client have in that case?
Really, your leverage there is to seek some judicial input,
Mhm.
and maybe depending on which Crown's office you're dealing with, you have a deputy who may be willing to speak to you if you really are at odds and you're in a stalemate with your Crown attorney, you can't get anywhere. Those are really the options that you have. Otherwise, you're
Take
threatening
it
to
to
have a
trial.
trial,
Yeah.
which in a lot of cases, most professionals, especially if it's somewhat high profile, they don't want to have a trial. They want to see it be resolved. So just do everything you can to, draw a good JPT judge, go in front of them, have all your preparations in hand and your opinions in hand, and try to garner the support of the judge to also uh, encourage the Crown to be reasonable.
All right. We also spoke briefly about that, but I would like us to talk more about this issue that. So we talked about the case where an a person is facing criminal charges, but sometimes they're still not facing it. They're under investigation at work, and there could potentially be criminal charges. So this is a little bit different here, but it's also very important and stressful for the client. So what do we do here when they know that their employer is investigating and that there could be some criminal charges coming their way? What should they do in that case,
This,
Jessica?
yeah, this is also very distressing for
Yeah.
clients, and it requires a delicate consultation and advice to them because sometimes they come to me and they tell me, like, yes, I did commit benefits fraud and I don't want to be charged. I don't want to lose my job. However, when they tell me that all signs point to they committed some kind of offense, I have to advise them that they probably shouldn't give a statement to their employer about that. They shouldn't incriminate
And they
themselves.
shouldn't talk to the police because sometimes clients will call and say, well, should I go and talk to the police and get more information about a potential investigation? I'm like, no, why do you want to?
Yes, we don't want to say, here's the fire to
Yeah.
the police. Yes, I know. And usually those types of reactions just come from naivety because
Mhm.
the
And
clients have
fear.
never dealt with the police before, and they think if they just tell the truth, the
Yeah.
police will be on their side, which is very endearing. And I let the clients know, unfortunately, this is not a circumstance
Yeah.
where the truth is going to be on your side. You have the right not to incriminate yourself, and so
Exactly.
let's not do that.
And if they want to talk to the client, like for anyone who's listening here, like if they want you, they will come and talk to you. Like, don't worry, don't expedite the process for the police. If they want to charge you, they will eventually come and talk to you. You don't need to go and make it easier for them.
No, and rarely, you and I both know from doing defense work for many years, rarely does that work out in the
Exactly.
client's
Yeah.
favor.
Yeah.
Almost never.
Yeah.
So, in the situation you're describing, what I try to just explain to clients is that in employment law, contrition and remorse are a big mitigating factor and can
Okay.
help you avoid being terminated. But if the employer has clear evidence that you've committed some form of misconduct, like a fraud,
And
that's
in a
not an
large amount, obviously, I'm guessing.
Right.
Like,
That's not going to be a situation where they're going to care what your
yeah.
explanation is, unfortunately. Like you said you got 180 pairs of contacts and you didn't. You said you went to 200 counseling sessions for your mental health and you didn't. That was a lie. They're not going to care what your mental health or mitigating circumstances were. All they
Mhm.
hear from the insurer is the insurer's done an investigation. Those providers say that those receipts did not come from them. They're not legitimate. And, they tell the employer that there's been some form of fraud. This is the
Mhm.
most frequent journey I'm seeing right now is these benefit frauds investigations. And unfortunately, the clients are just devastated. They think that they'll be able to talk their way out of it. But usually, because there could be a criminal element, I have to advise them of the joint jeopardy. Yes, you could be terminated, but this could lead to some form of a criminal charge. So we work out some kind of a plan where they pay back the money. They disgorge themselves of any unjust funds they came into and try to disincentivize the police from laying any kind of a fraud or theft charge. And then you try your best to work it out with the employer. In some cases, maybe the client can explain it. Maybe they were having a legitimate mental health issue or health issue, and that can explain the mistakes with the benefits provider. But in other cases where they tell me they just got greedy, like that's not going to be explainable. There's going to be no documentation that we can use to support their account of
Yeah.
what happened. And in those cases, they probably should just resign.
So really, it's resignation in this case. That would
Right.
be.
And walk away and try to be able to salvage their reputation and move on.
And so in that case, though, they might even have to find a different line of work. because if it's going to be if they have to leave for this job, it's going to be difficult for them to find something in the same field
Right.
with someone else. Well, speaking then of difficult areas of work, one thing that we're seeing that's becoming more and more common is Uber. A lot of people, especially students, international students, will study and they will do some Uber just to make some extra money. But Uber has some very harsh background checks, I would say. And many people who work for Uber, once they're facing criminal charges, they lose their job with Uber. So can we talk a little bit about that, Jessyca?
Right. Well, that is an example uh, of an employer who is concerned about reputational
Mm.
risk and also depending on the kind of background check that
Yeah,
you have to undergo to secure that employment. They want to know if you are charged with an offense that's going to put a patron or a customer at risk.
yeah,
Because at the end of the day, like we've spent most of this time talking about what it's like to be the accused or the employee, but I also advise employers when their employees are charged or when they've learned of some kind of conduct that may be criminal. And there are huge liabilities for the employer as well, right? Uber can't put some vulnerable young person in a car with a person who may put their safety at risk,
or an
right? So,
elderly person. Yeah,
right, anyone who's vulnerable,
yeah,
and as a society, we don't want that either. We
yeah.
want people who are vulnerable, who are taking some form of transit to be safe when they're doing so. So there is a balance to be struck there. It's obviously very unfortunate for a person who's driving Uber. They want to be able to keep their job and keep doing that. And we know that there's the presumption of innocence,
Right.
but at the same time, there has to be an understanding that this is a risk and a liability for the employer, which they have a duty to mitigate. They can't create a situation that's unsafe for the public. It's bad for them for business, it's bad for their reputation, and if something were to happen, they would be sued.
Well, and just one last area that I would like to cover, Jessyca, that's also on these a little bit more delicate situations are the people who are in Canada on a work permit, they're on a work visa, and then they're charged with a criminal offense. Like in these types of situations, it really feels like it's the end of the world for them because they're here because of their work. Work is extremely important for them because this is what keeps them here in the country. They're here for on that work visa permit, and now they're facing this criminal charge or these charges that could potentially just ruin everything for them. So, what do you do with these types of cases?
These are really difficult and
Yeah.
often very stressful for
Hmm.
these types of clients because
Yeah.
they've built their whole life around their job.
Hmm.
They've relocated. They may have even brought their family. Kids are newly in school in a new place. And then, if there is unfortunately some kind of domestic situation and one party gets charged, it really can upend everything. In these types of cases where the person's status in Canada is connected to their work, we want to do everything we can to preserve that working relationship. And that may be, like in this type of case, one where we want to try to get them on some kind of a leave, but they're not fired. They still have the work permit that's connected to the employer. And I would want to work very closely with the criminal defense lawyer about what the messaging is going to be and how quickly the resolution can be
Yeah.
put in place so that you can hopefully preserve that working relationship and the person doesn't have to lose their employment completely.
All right. Are there any final thoughts that you wanted to give or advice, especially for criminal lawyers um, who could be in this situation where they need advice, if there's anything? Final thoughts, Jessyca.
Sure. Well, absolutely reach out to me. We're at Greenwood Law. My partners are also amazing. Sabrina Feldman's a practicing criminal lawyer who also does some employment overlap.
Mhm.
And then my two partners, Hillary Page and Matt Chapman, are also the smartest people I know, and they've memorized the ESA, so they advise a lot of employer clients and those who need impact opinions around what we've been talking about. So any of my partners would be happy to help. But I think the most important thing that I've learned about, like in this area of practicing employment law, is that as criminal lawyers, we think of it more like a calling than like a business. And having all your ducks in a row yourself as a criminal lawyer in your business, having employment agreements, having workplace policies, those are all important pieces in the puzzle of having a polished law firm, a practice, and really protecting yourself as an employer and as a criminal lawyer. And oftentimes, we're just so busy doing the work
Yeah.
that we don't think about this. We don't really care. We hire people on a handshake, and that's just not really the way of the world anymore. It's not the way that the world is going, and you should paper your understanding. And so, if you need any help with that as a criminal lawyer, a big part of what I do is advising our own colleagues about their practice, about their law firm. And if you run into any difficulties with your staff or your associates and you need discreet advice, I'm here for that too.
That's very good to know that it's also not just for clients, but also for the lawyers themselves. Because they're also employers. Many of us are also, we have someone who we're, working with and supervising and who are employees. So that's also very good to know. I want to thank you, Jessyca. This was really very interesting, and I've learned a lot. There were some things that I knew of and others that I really didn't know about. So it was really very important to have this discussion because we know that many of our clients are going to be affected in one way or another by the criminal charges that they're facing. So for anyone watching this, Jessyca is really someone that you should reach out to and seek that maybe you should refer also your clients to retain for any kind of advice on the employment front. So thank you again, Jessyca, for your time. And I hope to see you again very soon for
I hope
another
so
interview.
too. It'd be nice to see you. And thanks for having me again.
It's my pleasure, Jessyca.